We're here today with Edmond Mack. He's Canton City Councilman, been a council person for 2 terms, and is running for his 3rd term, and he's out of the 8th ward, a Democrat. And one of Councilman Mack's big projects is getting Cantonians to agree to having a charter government in Canton. And rather than try to recreate history, I'm going to throw it to Councilman Mack, if he would, to give us a thumbnail sketch of what's gone on before and where we are right now on this particular issue.
Sure, absolutely. We started with the charter government issue probably 2 years ago, debating the issue in Canton City Council, the pros and cons, and whether this is something that the voters of Canton should consider, it being probably 50 years since they've considered this issue previously. It came to a vote before Canton City Council last year, and it failed 7-5. After that vote, myself, several other council members, and several other people in the community began collecting signatures to go an alternative route rather than through a vote of council to place the issue before the voters of the city of Canton. Probably about 3 weeks ago, the requisite number of signatures were gathered, and the signatures were submitted to the city, and the signatures were then submitted from the city to the Stark County Board of Elections for verification. 761 signatures were needed. The Stark County Board of Elections held a meeting last Friday, or rather July 3rd, to determine the validity of the signatures. And they certified 750 signatures. That's 11 short of the amount that's required by the Ohio Constitution. A big part of the reason, or a big issue, was the validity of one specific petition that was circulated. An entire petition was invalidated due to a discrepancy in the number of the signatures that were reflected on the petition. We filed a request for reconsideration with the Stark County Board of Elections that was filed last Wednesday, and asked for their immediate consideration of this issue so Canton City Council can pass the ordinance, the technical ordinance, to get this on the ballot. This morning, July 13th, the Board of Elections did agree to hear the request for reconsideration. Had they allowed the request for reconsideration, then the appropriate numbers of signatures would have been gathered, and the issue would appear on the November ballot. If they did not grant the request for reconsideration, then the charter ballot initiative would not have enough signatures. The board deadlocked 2-2 on the issue as to whether the charter issue should be presented before the board, for the voters on this November's election. In essence, they deadlocked on whether the decision invalidating the petition should be overturned. So, from here, the issue on that particular petition, which in essence is the entirety of the charter issue, goes to Secretary of State John Husted. The Board of Elections has 14 days to submit the materials to allow Secretary of State Husted to make his decision. And we could expect a decision from Secretary Husted within a few days after that. And then we'll know whether the charter issue will be before the voters in November.
Now, was there some discussion, and the sound system out at the Board of Elections is not very good. Sometimes I have to go back and look at my videotape to understand what happened. So pardon maybe the ignorance of this question.
Your vantage point isn't ideal at the Board of Elections.
Right. And so was there some discussion that, well, since there was a tie on the motion for reconsideration, then the original decision, which I think was 4-0 against certifying the adequate number of signatures, that since there was a tie on the motion for reconsideration, then just by virtue of the tie, it was over. Yeah. But you seem to think otherwise when you talk about the tie on this. So the Secretary of State can break, I think I follow your reasoning, and bear with me here, that if the Secretary of State breaks the tie in favor of reconsidering, then the board has to go back and vote again on whether or not those signatures on that one petition are valid.
Well, I think
do I understand that correctly?
Well, I think you do, and I think the way the motion was cast was whether to allow the issue to proceed onto the ballot and deem the petition valid. So while it wasn't technically a motion to reconsider and then have another vote, at least the way I understood how the motion was phrased, in sum or substance it'll function the same way.
Okay.
I think that when certainly there's an issue going to the Secretary of State on this. And
okay.
when the issue is going to be framed, it will be whether the petition was valid or whether the petition was invalid. I think once that tie is broken, then we in the City of Canton will know whether there was the requisite number of signatures and whether the matter should indeed proceed.
Should the Secretary of State vote in favor of denying the motion for reconsideration, is the matter over as far as you're concerned, or is there going to be a look at whether or not to take it into the courts?
We'll certainly look at that. There are a lot of people, not just myself, but a lot of people who have put a lot of time into this issue. I don't think anyone wants to let this issue die on the goal line. But filing a mandamus action is not a simple task. It's not something that should be taken lightly. While certainly I feel very strongly on the legal arguments that were presented to the Board of Elections, and I think that Secretary Houston will vote on our side. Whether that will lead to a mandamus action, that's a decision that we will have to make once we know what the Secretary of State does.
Okay, just one other matter on this particular issue is there's some chatter after the decision in the Chickenelli protest case today among various persons about your charter government issue matter. And one of the observations that was made, and perhaps you want to comment on this, well, there was a marginal notation about the question about two signatures, I think, being questionable as to whether or not they were valid signatures. However, in the count that someone has to put on the affidavit, is the count excluded the two questionable signatures, and that therefore made it a technical rather than a substantive issue. Would you care to comment on that?
Yeah, and that's exactly the issue. It is very technical. When you contrast that with the Chickenelli issues and the Burnaby issues that we've recently dealt with, those didn't concern the technicalities that go along with the petition. I think the board certified both petitions in both cases that they satisfied the technical requirements. Those cases deal with then the substantive legal requirements. On the charter issue, it's the opposite. It deals purely with the technical requirements on the petitions. And what had happened was the circulator in this case has a right, as any circulator does, to strike any signature that they would not like to present to the Board of Elections on a petition. That can be done by writing a line through a name, in which case, if in this case you have 28 spots for signatures, the numbers that you've stricken would not be reflected in your total signatures at the bottom of the petition. And so this case concerns with whether writing a notation that says omit, OMIT, next to two particular signatures identified with brackets is sufficient to strike those signatures. I think that under this set of facts it will be.
Right.
And the reason why is because when we talk about the Chickenelli case or the Burnaby case, there we're talking about candidates. The charter issue deals with the right of people to present a municipal initiative pursuant to the Constitution. The courts are very protective of that right, much more so than the right of a candidate to be on the ballot. And I think when you have a set of facts to where someone, a circulator, clearly wants to not include two particular signatures in their signature total, take steps to do so by saying, omit these signatures, I think that Secretary of State Husted is going to rule that the petitions are valid.
Of course, legal counsel for the board would be the Stark County Prosecutor's Office, correct?
Correct.
Have you any discussions with legal counsel about their take on this particular matter? Not
substantive discussions. I discussed the issue generally with Deborah Dawson, who's a very experienced prosecutor, very well versed in election law. When I was at the Board of Elections last Monday, we didn't discuss the nature of the arguments or what arguments we made. It was more, just so you're aware, Mr. Mack, a petition was invalidated. But of course, I made sure to CC her and provide her copies of everything that was filed because she is board's counsel, and the board's lucky to have her as their attorney because she's very knowledgeable in election law. And I think that the issue will be presented to Secretary of State Husted, and we'll see what happens.
So there you have it from Edmond Mack, who's really worked very hard to get this initiative going. And so we'll see where it goes from here.
Thank you, Martin.
Thank you.